Today is Tuesday, September 10th, and you are here at the Legislative and Human Resource Committee meeting. Our first item on our agenda is public comment. Is there anyone here that would like to address the committee? And you have 3 minutes.
How y'all doing, everybody? I'm D. Jones, passionate entrepreneur and visionary. First of all, see some people from 17th Circuit Court here. I just want to introduce myself again. I am D. Jones. I am the person who developed the Youth Justice Influence League, the esports league that some of y'all probably heard about, that has helped kids get off of probation, reduce court fines, and help it reduce recidivism. I am also helped our school district invest in the esports so the kids will actually have esports programs that they can get into, and we're also doing some cool things. I just want to tell a story about some call that I just got yesterday. So yesterday on my site, somebody put an inquiry in, and it was somebody from North Carolina, and they were like, I heard about the things you're doing in King County with this Youth Justice Esports League. We have 100 counties in North Carolina, and I know the chair of the Youth Justice Services for North Carolina, and I'd like to chat with you about doing what you're doing there in King County here in North Carolina. And I was just like, that's cool. It was a beautiful experience to be able to speak to him, because he's actually an educator. So he works in the public school system there in North Carolina. And he actually contacted me about doing this thing that I'm doing, this esports league here that I'm doing in King County, that I've started here in partnership with King County and coming here to King County board and going to the city board and school board. So I'm very active in the community. I'm very passionate, and I got to bring kids to the Detroit Lions facility. I'm still hearing about that. I probably, until I die, I probably will still hear about bringing people from King County government and youth on surveillance and probation to the Detroit Lions facility, because I still relive that every second of it. It still feels good to be able to have those special things and bring in kids and be able to broaden the horizons of our government, our youth, and just people just across the globe of what esports and gaming can do, and just being passionate and being compassionate and giving back to your community. I'm really passionate about gaming and esports, but really just reducing recidivism and just not having kids going down to the further down the justice system or end up dead. A lot of people don't have life insurance. We had a couple people die around our city, a girl, a guy around. They don't have life insurance, but they flash in thousands, and that's a problem in the black community that we need to solve. And so I've actually had people that work in life insurance that actually come educate these kids, because some of them didn't know if their parents end up dying, some of that debt has to go on to them, and they don't want to carry that, even if they living in poverty. It's just a lot that people have to deal with. So I'm just very excited to be able to give back, let you guys know that what I've developed here, other states are trying to do this, and I know eventually I'll be that global leader. I'll be a billionaire too, and I'm going to give back to King County. Thank you.
All right. Thank you, D. Jones. Is there anyone else that would like to address the committee? Seeing no one, we will move on to approval of last meeting's minutes. Do I have a motion by Teal, supported by DeBoer? Any comments, questions, changes? If not, all those in favor of approving last meeting's minutes, please say yes. 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 All those opposed? Those meetings minutes have been approved. All right, next item on our agenda, 17th Circuit Court Performance Measurement Review. Welcome and thank you.
Good morning, thanks. It's nice to be here. Greetings from our Chief Judge, Judge McNabb. She's over there judging at the moment, but she wanted me to send her regards. I got a few introductions to make, and we've actually kind of combined the presentation with the friend of the court, with FOC. So Tracy Schenkel, our FOC, will be joining me. Sandra Vanderheide, who is our not so new anymore Deputy Court Administrator, been here a year now, right? And Michelle Crow is the Deputy or Assistant FOC, and I brought Nick Little along as well. He is our trial court services, kind of the hub of the court where a lot of the logistics happen, and also a liaison or supervision over a lot of the judicial staff in the building. So, Circuit Court, what we do and why. I thought this was kind of timely because we have an election year and a few things have come up about probate versus circuit. So I thought it might be a good time to introduce what we do, and more importantly, sometimes what we don't do. So in Michigan, in the state of Michigan, we have the Circuit Court, which is us. We have probate and district courts as well. The Circuit Court, which is us. We're the Court of General Jurisdiction, which basically we handle all types of cases unless there's a specific law giving that jurisdiction to a different court. In our state, that would be district courts and probate courts. We handle the felony cases, so all criminal cases, trials and pleas and sentencings, and civil cases if dispute is over $25,000. Now, in our court, we break it down into two divisions of judges. One is criminal civil, so we have roughly 7 and 7 judges that do this. They also handle the appeals from the district court. And our family division cases handle domestic cases, mostly divorce, but also paternity, custody, personal protection orders. They also deal with juvenile delinquency and child welfare. There are a few kind of, oddball cases here and there, but that didn't make the slide. But we deal with those as well. I guess what you'd call the primary level of judicial authority in the state is the district court. Obviously, there are many in this county. The counties is the 63rd, and I believe you've heard their presentation, so I won't go too far into it, but they deal with misdemeanors. They do handle civil suits where the dispute is less than the $25,000. A lot of traffic offenses are handled down there, and they're the first stop for felony cases before they come to the circuit court. They basically find the probable cause to make sure that it belongs in the circuit court. And finally, probate court. Every county has a probate court, including Kent, and I believe they've already done their performance measures as well. Judge Rose and Judge Murkowski and Kaylee Gashko is their administrator. We have a relatively new probate judge. And I wanted to bring this up because we have an election coming up, and there are 2 judicial vacancies. And oddly, they're both going to be assigned to the circuit court, even though when you look at your ballot, one is going to be a probate court judge. I mean, the history of that is back in like the probably late 90s. The law changed to create a family court, or the family division. So a lot of probate courts handled that. And so I think just kind of a vestige of that is that some of the probate judges in this county were assigned to the circuit court to handle the delinquency, the neglect abuse, which is what used to be in the old probate court. And some stayed with kind of the probate cases that you're seeing here. That's never really changed. So we have 5 probate judges in the state. 3 of them are, in Kent County, 3 of them are assigned to the 17th Circuit Court in the family division. One kind of half family, half civil criminal. So one of those judges, Judge Hillary, is going to be retiring at the end of the year, so his seat is up for vacancy. That position will be, for all intents and purposes, a family division of circuit court judgeship, as will Judge Trusox being retired as well, and his position will also be in the family division. So when you're voting, both those seats are going to be in the family division of circuit court, probably for the foreseeable future. Our current chief judge believes that there's enough differences in the way that those divisions behave and practice that she would like there to be a lot of expertise and for you to stay in the family division if you're elected there, and stay in the criminal civil if you're elected there as well. So again, just a little bit of background and maybe a little education on the upcoming election. I'm not going to read all of these. These are the purposes of the court. But years ago, when court administration was kind of a new thing in the 60s and 70s, a lot of judges and justices and administrators got together to kind of develop, what is the purpose of the court, the fundamental purposes of the court. This is the list they came up with, again, all those years ago. And like I said, I'm not going to get into all of them. You can obviously read them at your leisure. But I bring them up to say that in recent years, a lot of experts, or I guess that's what you'd call them, experts, have been looking into probably a little bit, maybe we should add one more purpose of the court. And it is to promote coordination with justice and public health, social services, and other agencies to address common problems underlying the court's criminal and civil caseload, including substance abuse and mental health issues. And I think this manifests itself into some specialty courts that we've seen, or problem-solving courts, where the underlying issue might not be law-breaking behavior, even though that's what happens, but it's because there might be a mental health issue or because there's a substance abuse issue. So the idea of these courts is a little more treatment-oriented than maybe just, you did this, this is the sanction. Although that is sometimes included in what we do with specialty courts, as sanctions are sometimes warranted. Some challenges that we're foreseeing. Our judicial resources, the fallout from COVID, public trust, and some juvenile justice placement options. And for those of you who've heard me present before, the juvenile justice placement options, I think this is the third year running that we've had it as one of our challenges. First, judicial resources. Every couple of years, the National Center for State Courts does a weighted caseload study, where basically they do time studies of all the judges in the state, and then they determine, depending on what type of case type they're hearing, this is how many judicial minutes or how much time a judge should spend on that case. Then you look at the amount of filings of those case types in each court, and out comes a number of how many judges we should have in the court. Right now, the circuit court judge, the most recent weighted caseload study says 16. We have 14. We are keeping up, but obviously, as filings increase, as population increases, we are starting to feel a little bit of the pinch and the burden of the work that we're assigned. COVID fallout. We went from an organization that didn't change very much or very quickly. When COVID came, we changed very fundamentally what we do and how we do it. And as I said, I have there's a lot of discussions now as, you know, what do we keep from, like everyone, I don't think we're unique in this. What do we keep from COVID? What did we learn? What do we need to go back to the old way of doing, and that type of thing. And as I mentioned, I have 14 judges. I'll let you guess how many opinions we have of how much we should embrace COVID technology. But you know, but it can be confusing for the public too. You know, you think you got a Zoom hearing, you're supposed to be in person, vice versa. So we are trying to respond to that. We've made some Zoom rooms in the court, so if someone's in person, supposed to be Zoom, they have a place to go. It helps the attorneys because some attorneys have to be there in person for a motion, and then the next motion they're going to be remote. So again, a place for them to go. So we are responding to that. It's lots of discussions. It's lots of discussions, frankly, with human resources here too. To you know, how can we best provide remote work but still, you know, carry out our mission. Public trust. This is more of a nationwide issue. But I think that we did some surveying. Well, I know we did some surveying, and I think that that it might be creeping into our local branch as well. Again, the National Center does a nationwide survey and focus groups every year, and they've asked pretty much the same questions. And if you're interested, I can get you the entire survey, but I pulled two for this presentation. The first being the public trust and how much confidence do you have in each institution. And the state courts are the highest, based, you know, of these 5 options. And these options are the state legislature, the governor, federal courts, and the U.S. Supreme Court, and then the state courts. But the gap is narrowing, and it's something in court administration that we're noticing. And then the chart on the right, and I apologize, it's probably a little difficult to read, but the question asked, does the following word or phrase describe state courts? Very well, well, not well at all. Again, does it provide equal justice to all? And as you can see, the top or the blue line is when they're saying yes it does, and the bottom, the red, is they're saying no it doesn't. And you can see that gap narrowed and actually went upside down in 2021, where more people answering this survey thought that the courts did not provide equal justice to all. And then it took a pretty big leap in the wrong direction, in my opinion, in 2022. I think there were some things going on in the national press at the time about courts that probably didn't help the perception. And then 2023, you know, moving back in the right direction. But that's something that we're obviously keeping an eye on and trying to respond to in an appropriate way. I'm going to pass it over now. Oh, I did not add a slide for this, but I did want to touch on the juvenile justice placement options. Just to give you an idea, right now we have about a little over close to 60 kids that are placed out of the home for juvenile delinquency issues. And when I say place, I mean in treatment beds. This doesn't count detention, which is kind of a separate thing. Of those, over half of them, well over 20, are in out-of-state placements, meaning they're, you know, we're flying to see them. They're very far away from parents. And the reason for that is we just don't have a lot of options in the state to deal with them. Our response to that has been to create some detention pods or make some detention pods, treatment beds for youth. And we currently have 24 beds available for youth. We just got our girls program up and running. Our 2 boys programs are in a bit of transition. We had some new supervision, we've had some new leadership, and we're kind of changing how we do it. So right now we've got 15 kids in those beds. And the rest are in, beds throughout the state. And we have roughly 50 kids serving just in detention right now. And I believe, and I wrote it down and I didn't bring my notes, but I think I counted 17 youth that have been in our detention center that are awaiting a suitable institutional placement. And some of those kids, I think one of the kids has been, the worst case scenario, he's been in our detention facility for 300 days, or she has been in our facility for 300 days awaiting placement. But many, when they go over a month, we kind of start putting a highlight on them. It's like, okay, why have they been in detention so long? So we're seeing a lot of kids, waiting in detention for that placement. I believe there's been some discussion statewide to try and alleviate this. I do not know the progress of those discussions. Judge Ackert, I think, sat in a meeting last week with some of the decision makers at DHHS about this. I've not had a chance to catch up with him to see what progress there was in that meeting. But our response is to, I guess, make our own detention beds or our own secure treatment beds to deal with the youth that we have in this county that we think we can help and should be helped. With that, I'm going to pass it over to Tracy, our FOC.
Good morning. Great to see you this morning. Thanks for having me. Happy to talk a little bit about the Friend of the Court this morning. And when people hear Friend of the Court, usually the first thing folks think of is child support, right? Child support enforcement, child support collection. That is a big part of what we do, that is true, but that's not all of what we do. So I want to take a little bit of time today to dive into that and really dissect and talk about what that actually means. So Friend of the Court, we are first, maybe not first and foremost, it might depend on who you ask, but we are an arm of the circuit court, right? We fall under the 17th Circuit Court. But we are also part of this program that's called the Child Support Program. All right, well, what does that mean? The Child Support Program comes to us federally from the Social Security Act, specifically Title 4D of the Social Security Act. Now, many of us are just generally familiar with the Social Security Act and many of the different social safety net features of the Social Security Act, and Title 4D is no different. So Title 4 includes other safety nets for families, including Title 4A, which is temporary assistance for needy families that we sometimes refer to as cash assistance, child welfare, foster care, and Title 4D is the child support enforcement and establishment part of that federal act. So that's where it comes from, and the child support program itself is massive. When we think of any federal program, we can only imagine how massive that is. And in fact, there are I'm gonna look at my notes here. There are exactly 12.7 million children nationwide that are part of the child support program. To put that into perspective, that's 1 in 5 children that receive support from parents through the child support program financially. That tracks pretty closely with what we see in Kent County as well. So while the Friend of the Court is part of the 17th Circuit Court, we are also part of this child support program. Federally, we refer to that as the Office of Child Support Services. On the state level, we refer to that as the Office of Child Support. So if you're not confused enough, right, with the child support program, there are multiple agencies and institutions that interact with that program. And just thinking a little bit about, okay, how did this all come to be? What does this look like? How is Michigan different? Where does Michigan fit in? And then what about Kent County? Well, the child support program, believe it or not, was not a federal program until 1975. prior to that, each state was doing its own thing. And then in 1975, the federal government said, you know what, we need something consistent when we're talking about establishing paternity, establishing child support, enforcing and collecting child support. And that was in 1975. The first agency, however, kind of its kind, that pioneered this idea or this issue was actually Michigan in 1919. So significantly earlier than the federal program came about. And this you'll soon see in this history lesson I'm about to give you that no one asked for, how that came about and why. So if we go back, rewind the clock to the mid-1800s, and I have to give some credit here to the late and great Bill Camden, who was the friend of the court for Kent County from 1985 to 2002. A lot of this history is part of his legacy because he passed a lot of this history on to us. Mid-1800s, there were no laws against child abuse. Seems wild to us today, right? There was a case regarding a child. Her name was Mary Ellen. She was unfortunately quite severely physically abused by her mother. An advocate at the time, a child advocate named Etta Wheeler, took this case up and said, how can we prevent this from happening to children? This is a Michigan case. This happened in Michigan. How can we prevent this from happening to children in the future? What do we do? So she leaned on, interestingly enough, the Society for the Protection of Cruelty Against Animals. Because in the late 1800s, there were laws on the books that made it illegal to be cruel to animals, but none on the books that made it illegal to be cruel to children. So they made that analogy successfully in the late 1800s. And then in 1919, a judge in Wayne County, Michigan said, you know what, I need some help, right? Talking to a lot of parents, there are a lot of things going on. I need help with what do I do with custody or parenting time on cases? And what do I do when it comes to child support and spousal support? What do I do? So the friend of the court was born in 1919, the first one in the country of its kind, and then states slowly gathered momentum and got their own similar program that was administered at their localities. And then, of course, like I said, in 1975, we have the federal program. Okay, great, but that makes Michigan unique. Most states, and I don't say that lightly, most states, their child support program is, yes, they have their version of an OCS, a state-level organization, and they administer their program through their localities, through those local municipalities, their counties, and they do it predominantly as it relates to child support collection, enforcement, establishment, reviews and modification. And that's pretty much it. Now, it's very different in Michigan. Now, I will give credit to some of our other states here. There are states who will look at the establishment of a case, we'll talk more about that in a moment, that will look at setting parenting time schedules at the beginning of a case. Those states are Michigan, Texas, Ohio, Oregon, Illinois, and Florida. And that's it. And that's the extent of parenting time and how other states are addressing parenting time when it comes to its connection with child support. Parents do not bifurcate their children into child support and then that relational piece of being a parent, which really translates into that time they have to be a parent, which is their parenting time. I was at a national conference recently that was held in Detroit. It was the National Child Support Engagement Association, and they had a workshop, a session on innovative ways to deal with parenting time in the child support program. I was excited. I'm gonna go to this session, I'm gonna learn great ideas, I'm gonna bring them back. And Michigan was on the panel, as was Texas and Oregon and North Dakota. I thought, great, I can't wait to hear about this. Essentially, what the session was about using parenting time and the amount of parenting time a parent has to offset the amount of child support they pay. Michigan has been doing that for over 20 years. So this wasn't cutting edge for us, but it was a learning experience and a reminder of how unique the Michigan program is, because not only do we do all of those child support functions as mentioned, but we do parenting time establishment, parenting time enforcement, custody and parenting time investigations, and mediation services provided to families. So much more expansive in Michigan. The friend of the court, those words are unique to Michigan. You will not find the equivalent in other states. So Michigan, in so many ways, is sort of out in the front, sort of leading in this space of providing more services to parents. And in all of the interactions I have at the national level, that's the direction the federal child support program wants to go, providing more services to families. Michigan is leading in that charge. And I like to say that within Michigan, Kent County Friend of the Court is leading that charge. And yes, we provide mediation services. We provide those in-house. That's unique. We did 183 of those last year. We enforce parenting time for parents. We get over 2,000 complaints of parenting time per year. Those are parents who say, look, I have a parenting time order and this other parent is not playing along. They're not following the order. I need to see my kid. I want to see my child. I want that relationship with my child. We do the custody and parenting time investigations, about 600 of those per year. We do over 2,000 of the child support reviews. And then, of course, all of the child support enforcement functions as well. So we have a really expansive, comprehensive program. And that doesn't even include the fact that we have a Resources for Parents program that works with parents who are struggling to pay their child support, to provide them options, to work with them on a bi-weekly basis to set goals and meet those goals, whether it's finding employment, whether it's setting parenting time, whether it's getting help for substance abuse treatment, whether it is connecting with a parent mentor in a partner agency in the community. And we have an early engagement program. So when folks have a new friend of the court case, we have a dedicated individual who reaches out to that parent. Says, look, you have a child support case. Do you know what that means? Do you know what friend of the court is and what we do? What concerns and questions do you have so they can direct them to services and give them some information as it relates to their case? So even within Michigan, friend of the court is unique. And when we think about the alternative, what's the alternative? If a parent wants to, let's say, change their parenting time order, they can sign up for mediation, meet with someone in our office. We will do the parenting time order. We will facilitate the entry of that order. When we get that back signed by the judge, we will send it everywhere it needs to go so parents don't have to worry about some of those procedural court rule details that can be very difficult to understand. The alternative, too, if we think about enforcing parenting time, a parent doing that on their own, or enforcing child support on their own. Again, they have to file something with the court and do all the things we need to do in court, like service, show up for a hearing, present your case, draft the order, send the orders out, then file a proof of service with the court proving that you've done that. And those are very difficult things for regular parents, everyday parents, to navigate. So the alternative is more time-consuming, it's more confusing, and it's certainly more expensive. It's very easy to say to a parent, well, just go file a motion with the court and ask the judge. And our judges do a fantastic job. And they hear things in a very timely manner. But the process takes time. And it can take 6 months sometimes to work all the way through some of those processes. So FOC is unique to Michigan. Kent County, I'm proud of our team. I'm proud of the folks that work very hard every day to make what we do unique. Now, well, how does friend of the court case even start? This is important because this is something I hear in the community frequently, that parents and community partners do not know how cases start. Over 60% of our cases start with a state-initiated referral. How that happens is a parent will apply for state assistance, Medicaid, cash assistance, food stamps, et cetera, and that will initiate an automatic referral to the Office of Child Support, who will start collecting information. They will get the information, send then that referral to the prosecuting attorney's office in Kent County, and that's the folks who will actually file the case. And they will set that first order for child support or paternity. And they do that through going to the court. And then after everything's said and done, then it comes to friend of the court. And then we provide services there. That's 62%. The other 38% are private filings by parents, divorce filings, custody filings, support filings, where a parent files directly with the court on their own, go to court, get the order, and then it comes to friend of the court. We have about 35,000 cases overall, and that's a lot of parents. And it's even more when we think of folks that have had interaction with our office in the past and those that will have interaction with our office in the future. And we're working hard and being very intentional about changing our image. We know there are barriers to folks wanting to interact with our office. Our approach has been threefold: through community outreach, education, and response. Education is, we have a program, we call it, sometimes we like to call it FOC 101 or FOC Academy, where we have programming that will go out into the community, whether it's with parent groups or community partners, and educate on what our office does and the services we have that we can provide. So we have done this at various agencies: YWCA, CPS, HealthNet, the Health Department, Safe Haven, Alpha Grand Rapids, to name a few of those. We also have a lot of programming that we're doing around being responsive to the needs of the community. One example I'll give is we have an internal domestic violence work group that has done some listening sessions at the YWCA and at Safe Haven and said, you know what, there are some things that we should work on. So we've been able to work on those collaboratively in-house and change some of the things that we do to make it safer so folks can more meaningfully participate in the services that we provide. So being responsive. Also another way that we're being responsive, and I have to credit Michelle Crow for this one, is getting a lot of our literature and our forms translated into Spanish so that they're just more accessible and more easy for parents to understand that way as well. And then finally, and certainly last but not least, outreach. We spend a lot of time in outreach. We hear a lot. I get the opportunity to hear a lot directly from parents with lived experience about what their experience has been like. Gives us a lot of ideas of what we can change. We did 39 outreaches in 2023. Our goal for 24 was 50, and through August, we've done 54. And we're proud of those. We see some of the pictures here. Just one I'll point out is the picture in the corner there with the kiddos. That was actually at a spring mixer. We partnered with a fatherhood group, and we were asked to judge the dance competition for the kiddos. So that's what we did. And we just think about that friend of the court as at a community event being judges for a kid's dance-off. Very, very cool. And we were honored to be there, and it was a great time, above all else. And I'll also, I'd be remiss if I didn't say that our deputy program is a big part of our outreach too. Over 99% of the bench warrants we have are resolved by our deputies without any arrest, because they're going into the community where the parents are, helping them resolve their warrant, and at the same time able to refer them to other services within our office to address other concerns that they have. So that's a little bit about friend of the court. I could go on longer. I won't, because I'm going to turn it back over now to Sandra.
All right, after working in Muskegon the past 12 years, but always living in Kent County, I was fortunate to make the transition here a year ago. And in Muskegon, in the circuit court, we had 130 employees, and that included all of the juvenile detention employees. So when Andy told me that the circuit court here in Kent County has 400 staff, it was very eye-opening to me for the amount of court users and litigants that we have. Here in Kent County, we have 14 judges. That is 7 judges that do civil and criminal cases, and then 7 judges in the family division, which is the domestic, neglect, abuse, and juvenile delinquency. And each of the 7 family division judges has a referee that helps with a lot of the matters, especially the post-judgment matters. And as you can see underneath the just under 400 staff, you see all the different sections that make up our circuit court. All right, they say the exciting stuff for me. This is the performance measures. So, timelines. This is how quickly we process our cases. The State Court Administrative Office sets these time guidelines. So an example of one that they set is divorce with minor children. They say that 95% of our cases divorce with minor children should be resolved by having a final judgment within 364 days. And as you can see, our number is 96%. All of our percentages are looking really good. We are still a little bit under what our COVID numbers were, but it was interesting even recently to hear some of the judges say, we might not ever make it to our pre-COVID numbers because of how complex the cases have become since COVID. But that's one of our goals. In a little bit, Andy's gonna talk more about our strategic plan. We hope to improve our timelines, and one of the things that we're doing is we are going paperless, so that should be something that's gonna help with our timelines. All right, clearance rates, another really exciting topic. This is how quickly we are able to process our cases. So as far as, well, what it does is it measures the extent to which the court is keeping up with the number of cases filed and tells the court if we have a backlog. So to calculate this number, they take our outgoing cases and divide it by our incoming cases. So for example, for our PPOs, you see that we're at 100%. That's because in 2023, there was 3,025 PPOs filed, that's right, 3,025, and we had 3,025 cases resolved in 2023. PPOs have a very quick turnaround, they do have to get resolved quickly. Unfortunately, we're at 100%, even with such a high number. Every once in a while, we have some exceptions, such as when asbestos cases were able to be filed. There was so many of them that threw off our clearance rates temporarily, but otherwise, we're very close to the 100% mark. As part of our strategic planning, we're working with somebody who's out of Colorado, Brenda Wagenknecht-Ivy, and she's worked with a lot of courts in Michigan. Al's probably familiar with her from all the work she's done with Ottawa County. But when she started working with us on our strategic planning a few months ago, she had us do surveys for all of our external partners as well as our internal partners. What you see here on the left side is with the orange and the, I think, dark blue. That's how many of our external partners and our judges and employees thought that we are doing good or excellent. So in total, we had 59% of our external partners say that they think that we're doing good or excellent, and 64% of our judges and employees say that we're doing good or excellent. And then the right-hand side, you can see that overall we were given almost a 4 by both our external partners and our judges and employees, which means that overall they think that we're doing good. And even Brenda, who's working with us, said that that's higher than what she's seen in a lot of courts. But again, it gives us a baseline now, and our goal is only to go up. And this also came from the surveys. This shows the court users' experience. You can see that we're typically between a 4 or 5, and the 4 is that they agree somewhat, and 5 is agree. We're highest in our virtual proceedings and our quality and effectiveness. We also did a survey to the Grand Rapids Bar Association over the last year, asking them, okay, post-COVID, do you prefer in-person hearings now? Do you prefer 100% virtual proceedings, or do you prefer hybrid? Hybrid, hands down, is the future of the courts, and that is what our attorneys said. Because case by case, there's some cases where it does make sense to be in person if there's a lot of evidence being submitted. So for those evidentiary hearings, a lot of times they're in person. But with a lot of our civil cases, do we really want to make people drive and pay for parking downtown, have to worry about daycare? No, we're able to have them participate virtually, and it also helps our attorneys to be able to spend time with their clients because they're not having to constantly be in the courthouse.
Thanks. So I'll quickly go through some of the current things that we're working on over the next year. As Sandra mentioned, strategic planning. Basically, the surveys that we saw from external and internal were pretty consistent with each other. And the needs or the focus areas that they suggested are timely resolution of cases to get faster with those, technology, equal treatment, and some community-based programming and more access to those types of things. And the internal survey, the staff were basically hoping for workforce development. So those are kind of our strategic focus areas moving forward. We're going to be honing those in at actual goals and projects here in the coming months. Juvenile justice reform is Well, October 1st is the kind of, I guess, soft opening the state is telling us about some of the new reforms that we have to implement that would be considered best practice for juvenile justice. Most of these reforms are kind of on the front end of things. Screening instruments for both, before accepting petitions or before allowing a youth to be lodged into the detention center. Standardized risk assessment tools for treatment decisions for when kids do go formal or are on probation. They have eliminated our ability to collect fines and costs for juvenile cases. And I think that's pretty much the main ones, right? And we're pretty well suited. We were doing a lot of that stuff prior to this, but there are some hoops that we need to jump through to make sure that we're meeting the requirements for funding. And I will say that the state has returned these obligations with an increase in funding, going from 50% reimbursement for these services to 75% reimbursement for these services. And including some of the services that would not have been reimbursable before, diversion from court, those types of things, which typically were not reimbursable. So in this case, at least, the state is ponying up and helping pay for some of these changes. And then Operation Paperless, which is our term for making all digital files and for making, eventually get to a full electronic filing system in a paperless court. We've had very good success so far with the contractor. Sandra should probably be talking about this because she is definitely taking a huge lead. Nick as well has been, they've been very busy on top of their regular jobs, dealing with the contractor, going through all our processes, getting them, pen to paper so that we can figure out what this needs to look like. We're hopeful that civil cases will be electronic by the end of the year. Again, there's some testing that has to happen and some, tweaks and changes to be made. But we feel like we're off to a very good start. We've got a lot of support from everyone that needs to be supporting us. We've got a kind of a cultural change committee that the HR director has stepped in on. That was actually Al's idea to include. It's been very well received by our employees. This is where all the employees can kind of be kept in the loop and kind of be champions for what we're doing. IT has been very involved, working with us and the vendors. And the contractor, and really everyone at the court, the clerk's office. I mean, a lot of people are stepping up. It's actually, in a way, kind of fun to see, even though it is an incredible amount of work for a lot of people besides me. So, so that's it. That's the presentation. We might have went a little over what we thought we would, but available for any questions that you might have.
Wonderful. Thank you so much. Appreciate it. Commissioner Ponstein.
Thank you, Chair Burrow. Andrew, thanks for being here. Thanks for your staff being here, too. It's not an easy job to do, to be a part of the court system, because it's a very uncomfortable place for people to be. Doesn't matter what side they're on. So you talked briefly about COVID and what we've learned and not learned. What was the peak of the backlog, because basically courts shut down for a little bit of the criminal cases, and how long has it taken to get back caught up?
Yeah, yep. So I might be able to give some exact numbers. At one point, and when we couldn't have trials, and that was really the killer, so to speak, for our criminal case. So the way we would judge that is, as Sandra mentioned, with performance measures, we want to get done with our criminal cases within a year, roughly, and that's kind of the goal for each one. So we considered backlog anything that was still pending that was already over that deadline. And I want to say at our worst, Nick, was it 400? Yeah, it was a little over 400 at one point. And we've kind of been digging out, and now we're around 45, 50. Is that about right? Yeah, so we're about 45, 50 right now. Now, I will say prior to COVID, that number was 15 to 20, and this is court-wide. So again, I feel like we're kind of past it, but I don't know, that might be kind of the new normal.
Okay, so then to the meat of my question then, I know the cases are logged by someone, you have clearance rates. What were the numbers for the civil cases? How far of a backlog was that, and where are we at today?
So, okay, I don't know if I have the answer, and I don't know, I can get that for
Yeah,
you,
you
but.
can, you can get it to me, and I guess my point is I talked to someone that was involved in a civil case, and it was a lot more than 25,000, close to $500,000. And it started at the beginning of COVID, and they are just finishing up now. And I guess my question, and it showed on some of your polling on, do people think the courts are fair? I mean, how do we log that a criminal case is more important than a civil case or a divorce case or all? I mean, how do we rank them, and how do we say this is more important than your case that's maybe very important to the person that's affected by it?
Yeah, I mean, I would say that, again, especially in criminal cases, when you have people sitting in jail or detention, you have victims waiting to be, for justice to be done for them and their families, that certainly weighs into it, without diminishing the fact that, yes, everyone that comes to that building is entitled to a decision as quickly as we can get it. I believe the civil case is a 2-year time frame versus the 1-year time frame. But yeah, and I can get you what the civil backlog was. I'm not sure.
Because, I mean, everyone's affected by anything within the court system. And, I'm hearing during COVID, the headlines in the news was always people that are taking money from people to do things to their homes or build homes, and then they don't. And those lives are affected, especially if someone that's already in the process of building a new home, the guy never does it, took the money, and now they're just sitting there without a home. I mean, that's, to me, just as bad as a criminal sitting in jail because he committed a crime. This person did nothing and is sitting without a home. So, thank you.
All right, any other commissioners? Commissioner Bujak.
Thank you, Chair Burrow. Andrew and your team, appreciate you coming here and educating us. As a county commissioner, I find the court, the whole concept of the court, very difficult to put my mind around and understand. And I think it's probably because I've never been personally involved in any of the court's, activities other than jury duty. So, and that's probably a good thing. But the opportunity to learn and find out that, Michigan's on the leading edge with front of the court, I think that's great. I have been to the juvenile detention center. I'm concerned about what I've seen there. We're at maximum capacity. You spoke of another program where now we're looking at treatment to try to keep these children that are having difficulties out of that system. And having to send them out of state, to me, that's very much a hardship on the families. So I think bringing that in-house makes sense. And my question is, where are we doing that? And because it can't be there at the juvenile detention, it's full.
Right now, we have the detention center. It's a 98-bed facility. 24 of those beds are now devoted to treatment. So that leaves 74 beds for straight detention. As of this morning, we had 47 kids in detention and 15 in our treatment. So while last summer we definitely were experiencing overcrowding and we were at capacity, that hasn't been the case for the past 12 to 15 months.
And that's great news because I think the whole concept of going with the treatment program is trying to understand root cause. Why are we societally having these issues, these problems? And rather than just being reactive and putting kids in jail or putting them in detention, what can we do to prevent that from happening? And are there ways to educate or work with juveniles who are reaching out? They really probably do want help and just don't know where to get it, don't know how to get it, and end up in trouble and getting caught. And then we have to deal with that. If we can find a way, preventative methods to, deal with this societal problem, I think that's probably the best way to go. And I'm glad to hear that the juvenile detention's not full. The last time several of us commissioners went there, it was at capacity, and it very much seemed like a problem, because I don't want to have to build another building.
Right. And
Thank you.
And I guess I want to respond in two ways to what you've asked. I'm really glad you asked the question and brought something up. But the first is that capacity can mean two things. It can mean, how many beds we have and how big the building is, but it also can mean staff, because we're required by license to have so many staff per youth. There have been times when we were severely understaffed, especially during COVID and coming out of it, to where, we had what I'll call our kick-out list, meaning we can't take any more kids at, 60, 65. That has not been the case either. We've done a great job, again, been a team effort with HR and our detention staff to get that up and fully staffed. And I think at one point, we had over 30 vacancies in youth specialists, which is kind of the frontline staff. And I think as last report I got, we have 2. So we've made a huge stride in there. And I did want to mention too that a lot of times that the kids going to detention or the kids that have to go to placement get a lot of attention. We get hundreds and hundreds and hundreds of referrals to juvenile court. And the huge majority, I would say 90 to 95%, we deal with, that's the end of it. We get services, we get treatment in place, we get a program involved, whatever it might be, and that's it. We have, I think, probably a little over 300 kids on detention right now, or 350 kids on detention right now, or I'm sorry, on probation right now. And as I said, we're at about 55 of them are actually placed out of the home. So our community probation recidivism numbers are very good. I think less than 15% get referred for another law violation within a year or two of being discharged from community probation. So a lot of those services are in place. We have been doing them for a while. Obviously, we've got an issue right now with some of those youth that don't respond as well. And we are trying new things. We're trying, esports, and we're really moving towards, and part of this impetus is because it's the right thing to do, and we're kind of moving there. But I think that the JJ reform has kind of pushed us along and giving us the budget to do it, is to move more towards programs like esports or more of these treatment type programs for kids that we use for surveillance, where it's kind of extra monitoring of kids. Let's plug some services in as well. So yes, I believe that that sending a kid out of state is probably not the best thing, but it's our only option, and it is a hardship for the family if we want the families to stay involved. It's a hardship for our staff to visit the kids as much as we'd like them to as well. But I will say, by and large, the vast majority of the kids that are referred to our community probation program are dealt with effectively and not necessarily needing those treatment. It's those kids that do that we need to figure out a better way to go.
Commissioner LeGrand.
Thank you, Chair. I have a few questions for both of the programs. You mentioned that the report said we needed 16 judges and we have 14. Does that count the new judgeship that was created for the 63rd District?
I put those weighted caseloads break down for district, circuit, and probate. So what I quoted was just the circuit.
Just circuit, okay,
Yeah.
so that doesn't affect
Correct.
it at all, okay. And then can you talk a little bit about who decides that line between detention and whatever the other treatment for juvenile offenders? Does the judge make that call, and is it based on severity of crime, or what are you looking at?
That's a judicial decision. So it'd be a judge or a referee that hears the case and the facts of the case will then decide whether that youth needs to be detained or not. Sometimes there's a bond offered. The juveniles are pretty much afforded the same rights as adults in our system. So absent a conviction or an adjudication, they're in detention without proving being done. So there might be bonds where kids are released at that point. But yeah, those are judicial decisions of the level of, I guess, confinement or security that a youth has.
Okay, and is there any thought that the that the state government will provide more funding for juveniles, or is it a funding issue, or is it a personnel issue that we just can't find the people, or?
I think it's a resource issue as far as having these beds available. I mean, we have, I'll give an example. Highfields is a in-state residential treatment center outside of Lansing. I was talking to the head of community probation, our juvenile services manager yesterday, and he said they always have a wait list that's forever. You know, seems like 100 years ago, I used to work for the Bureau of Juvenile Justice in the state of Michigan, and when I did, at its peak, I think that Maxie Boys Training School had 300 to 400 beds. And Maxie Boys Training School was the end of the road. This was, look, we've tried everything. We're seeing felonies, we're seeing dangerous kids, that type of thing. 350 beds, there are none now. The Maxie Boys Training School is gone. We had Maxie Boys Training School, we had Green Oak Center, which was across the street, which was typically for very violent sex offenders. I want to say there were 50 beds there. We had Adrian Training School, which was in Adrian, of course, for girls, I think 120 beds. Shawano and Nokomis, both in northern Michigan, each had 40 beds, and Bay Pines had around 80. I'm quoting my memory, don't quote me on that, it's kind of what I remember. Now we have, for the state, we have Shawano and we have Bay Pines. You know, there used to be probably 700 beds for these high-end kids a long time ago. And to be honest, 700 was way too high. I mean, we didn't need that many. So the cutting happened, and I think appropriately so. But now we're seeing maybe it went a little too far.
Okay.
My opinion.
And then if I just have a quick question about the friend of the court. You mentioned the internal domestic violence work group. Maybe this is for both of you. I'm just wondering about the new court that's being created for domestic violence. Are you interacting with that? And how does the DV court interact with the 17th Circuit is another question, I guess.
Absolutely. I'll take the friend of the court portion, and thank you for asking that. And we have folks that are on our, sorry?
Sarah, go ahead.
Okay. Who are on our internal domestic violence worker for friend of the court, who are also on DVAN, which is the Domestic Violence Action Network. And part of what they're doing, of course, is setting up the court with the ARPA funds. And we have 3 individuals from Friend of the Court that are represented in that body and working in work groups to get things up and running and working in the court. And then we have 2 folks specifically that I really want to give a lot of credit to. That's Elizabeth Hayes and Alyssa Wiggers. Both of them are mediator evaluators in a Friend of Court office. And they have met with and worked with the case managers that are going to be working in the domestic violence court to figure out how do we help address the family law issues that are inevitably going to come up in those domestic violence court cases, because those are going to be predominantly misdemeanor level domestic violence criminal cases. Well, that's not a family law case, but what's going to happen? There might be a no contact order that's put in place. Okay, that makes sense, but then what do we do about parenting time? Right, what happens there? So we've worked out a way for folks in our office to then be liaisons to the caseworkers who are working those cases with the domestic violence court. Does that answer your question?
Yeah, thank you.
Anything to add, Andy?
No, nothing to add. Those are actually more at the district court level as well.
Okay.
Specialty courts or problem-solving courts, we do have a few, but they're kind of rare at circuit court because usually it's kind of the early offenders where district court is going to see them first. So in
That
those
makes sense.
instances, they're at district.
Okay. And then you just mentioned that the child support issues resolved by deputies. We're talking about sheriffs, deputies? Yeah, okay. And so that's collecting child support or enforcing that, or what exactly is their involvement?
Yeah, absolutely. We have 3 deputies assigned to us from the Kent County Sheriff's Office. And we work with them. We have incentive monies that we get from federal incentives from the 4D program that help us fund this program. So they are assigned to our office, and they work with, we pull reports for them, and so they can make calls and go try to find parents out in the community and resolve the warrant. And that usually looks like some kind of payment. And they're able to go either help folks get to where they need to be to make that payment, collect the payment right there on the spot in the community as well, and get those warrants resolved and lifted so that that parent no longer has to worry about being picked up on a warrant.
And do they operate countywide or only outside of, like, we have our own police force in Grand Rapids? Is it always the sheriff who does that, or do police officers do it in municipalities that have a force?
Our deputies do work countywide.
Okay.
But there's just the 3 of them that work throughout Kent County. Fortunately, they have great relationships with some of the other law enforcement agencies as well. So if they do encounter a parent that they know has a friend of the court warrant, because they can see that in lien, oftentimes they will reach out to our deputies to try to prevent parents from being taken into custody. The last thing we want is for parents to be taken into custody.
Right.
That isn't good for kiddos. That isn't good for helping parents get into compliance with their orders. That is not the case. But it does give us an opportunity to interact with parents who, for whatever variety of reasons, don't take our calls, or don't open their mail, or don't open their email, or don't interact with us. Sometimes that's the last resort.
Okay, thank you.
Absolutely.
Thank you, Chair.
All right, any other commissioners? All right, well, thank you very much. Appreciate the team coming, and excellent presentation. Again, appreciate it, and we'll see you next year.
Thank you.
Thank you
All
so
right,
much.
thank you so much. All right, next on our agenda is miscellaneous. Is there any commissioner miscellaneous? All right, seeing none, meeting is adjourned.